Two Los Angeles-based federal judges speaking out today on what they call an unprecedented wave of threats, intimidation, and personal attacks that they've endured as a result of rulings deemed unfair and politically motivated.
And they are not the only ones speaking out this week. Supreme Court Chief Justice John Roberts appearing at Rice University earlier this week, addressing criticism of the court, which he says is emerging from all over, not just any one political perspective. Roberts stressing that, quote, a lot of what we do is of necessity controversial. Some of the criticism is very healthy. Some of it is not. It's important to keep the facts before you.
All right. And with more, we are joined by Loyola Law professor and now KTLA Law and Politics analyst, Jessica Levinson. Welcome to the team officially.
I'm so excited.
We're so excited. Every Thursday you'll be here and we'll be discussing a whole slew of things. And today, of course, we're talking about Chief Justice John Roberts, among other things. He didn't mention President Trump by name at Rice University, and that came hours.
All right, folks, welcome to Jack Mockler. Right now, Supreme Court justices have broken their traditional silence to push back against Trump's sustained personal attacks, calling them fools, lapdogs, and a disgrace to the nation, while suggesting they've been influenced by foreign interests. The unprecedented public responses signal that the president's behavior has crossed a line, provoking institutional pushback unlike anything in modern American history. Chief Justice John Roberts, a man who has spent his entire career thinking about how to protect the court's institutional standing, gave a rare public speech in which he addressed the pattern of attacks directly. Roberts did not mention the president by name. That was a deliberate choice, a way of maintaining the institutional posture of the Chief Justice, speaking about principles rather than engaging in political combat.
After Trump had already wrote that lengthy post on Truth Social, what do you say about this kind of, back and forth that's happening here?
I think he didn't have to mention President Trump by name because we all know what was posted on Truth Social a few hours before. And this is, I think, about the third situation where President Trump has directly attacked a judge or the judiciary based on decisions that people make that he doesn't like. And it's the third situation where, not where the president has criticized, but where you see the Chief Justice, the head of the federal judiciary, saying, I just want to tell you what we do. We are not Obama judges and Bush judges and Trump judges and Clinton judges. We are judges doing our level best. We are judges making decisions. I thought what he said this week was so powerful in trying to push back, saying you can disagree. We disagree with each other, but there's a difference between attacking me as a person and undermining my safety, because we know the safety of the federal judiciary is a big issue.
But the target of his remarks was unmistakable to everyone who heard them. Roberts said that criticism of legal decisions is part of the job. Judges understand they will face criticism when they rule in ways that disappoint powerful people. Criticism of outcomes is both legitimate and expected. But then he drew a line. He said that personally directed hostility, attacks on individual judges by name, attacks that question their motives, their integrity, and their loyalty, is perilous. He said such attacks are dangerous, and he said they have got to stop. 3 short declarative sentences from the Chief Justice of the United States, directed at the President of the United States, about a pattern of behavior.
And criticizing my legal analysis. And you heard the federal judge who was interviewing him saying, thank you for having our back. This is on the minds of not just federal judges, but judges throughout the country.
So the president making his opinion clear and very public, and this coming on the eve of a number of big cases the Supreme Court will be dealing with on the docket in the weeks ahead. Give us that sort of view from 30,000 feet of what we can look forward to.
So we're going to be able to talk about all these big cases. So tomorrow is a decision day. We're waiting on some big cases dealing with the Second Amendment. There's a big voting rights case. There's a case that's going to be argued on Monday dealing with something similar to what California has when we vote, which is a grace period. You can mail in your ballot the day of the election, and as long as it's received within a certain amount of time, it still counts. The court's going to be hearing a case on that. Of course, the big birthright citizenship case That will be heard on April 1st. And then we can't have a conversation about this term in the Supreme Court without talking about the transgender athletes cases. Everybody's going to be watching them to see how the court continues to tackle this huge issue.
That the Chief Justice has concluded threatens the safety of judges and the institutional integrity of the court. That is remarkable. And the word dangerous is not rhetorical. It is a direct acknowledgement that personal attacks on named judges create environments in which those judges face real physical threats. The federal judiciary's own threat tracking data shows that threats against judges increase significantly when high-profile public figures attack them by name and question their integrity and motives. Roberts knows that data. He has access to the security reports, and when he says the attacks are dangerous, he is not speaking metaphorically. He is speaking about actual physical danger to actual human beings who serve the judiciary.
Okay, so President Trump writing on Truth Social that the Supreme Court has become, quote, little more than a weaponized and unjust political organization, adding that the sad thing is they, referring to the justices, will only get worse. What is your reaction to that? And given that Trump faced more nationwide injunctions than in his first 5 years than, 40 years of presidents combined?
Yeah, I love this question because it points out the fact that, yes, he's going to lose more than other presidents because he's doing so much more in part, and he's pushing the legal boundaries so much more. So he's saying there's no president who's ever been stopped by the federal judiciary to this extent. I think part of the response to that is there's no president who has used this many executive orders to try and make really big changes. That doesn't mean just because you use a lot of executive orders that by definition, that means they're legally problematic. But one thing I really want people to look at is when the federal judges issue these injunctions and say, you can't do X, you can't do Y, maybe it's immigration, maybe it's birthright citizenship, maybe it's about the environment.
Justice Neil Gorsuch added a dimension to the pushback that is uniquely powerful given his specific history. Gorsuch was Trump's first Supreme Court appointment. Trump nominated him. The Senate confirmed him. He is in many respects the most direct beneficiary of Trump's electoral victory in terms of career advancement. Yet, when asked directly about Trump's suggestion that justices owe loyalty to the president who appointed them, Gorsuch's response was clear and unambiguous. He said his loyalty is to the Constitution and the laws of the United States. And he added, "It is really just that simple." 4 words that carry an enormous amount of weight. That is Gorsuch, Trump's own appointee.
We are not talking about judges who are all appointed by presidents of one party or another party. So is there a point here? Absolutely. But we have to look one step below and really think about the number of executive orders he's issuing that have been challenged.
The president, there in reporting this week, may, it is believed, have less of an impact on the judicial branch in his second term than he did on the first. Fewer Court of Appeals confirmations so far, fewer overall vacancies, a slower pace of retirements, and as the potential midterm results could make confirmations even harder. What is your sense of his impact on the judicial branch to this point?
I think it's been enormous. So is it less so far this term? Yes, but we have to look at the benchmark, which is he had a huge impact. I think he was very strategic and extremely effective at saying this is a priority. And he's exactly right. And every president is right to say that. Who you appoint to the federal bench outlives you because all these members of the federal bench serve for life. So when we think about the Supreme Court, 3 of the 9 members of the court, but the vast majority of cases are decided by lower court judges.
Publicly rejecting the premise that presidential appointment creates a loyalty obligation. Publicly asserting that his judicial independence is genuine and not contingent on the political preferences of the person who nominated him. And publicly doing so in an interview format where his words would be directly quoted and distributed to a national audience. Justice Ketanji Brown Jackson brought a different perspective to the public pushback. Jackson was appointed by President Biden. She joined the court representing a very different political and jurisprudential perspective from the conservative majority. and she has been one of the most publicly vocal justices about the specific threat she believes Trump world attacks on the judiciary represent. Jackson's characterization of the attacks goes beyond saying they are wrong or inappropriate. She has argued that they are not random, that they are seemingly intended to intimidate the judiciary. That is a specific and serious allegation. Intimidation of judges is not just bad rhetoric. It is a specific form of conduct that strikes at the core of what judicial independence is supposed to protect. A judge who makes decisions under the fear of presidential attack or under the fear of physical threat generated by presidential attack is not an independent judge. Jackson's argument that the pattern and targeting of the attacks suggests intentional intimidation rather than accidental excess is a claim about the purpose and effect of what the president is doing that goes well beyond normal political criticism of court decisions. She has also said explicitly that these attacks threaten democracy and the rule of law. Not just the specific judges being attacked, and not just the specific decisions being challenged, but the foundational institutional arrangement on which democratic governance depends. The fact that 3 justices spanning the political spectrum of the court, Roberts appointed by a Republican president, Gorsuch appointed by Trump himself, and Jackson appointed by a Democratic president, are all making versions of the same argument tells you something important about the nature of the threat they are perceiving. When justices who disagree about almost everything constitutional agree that a specific pattern of behavior threatens the institution they all serve, that convergence is meaningful. It suggests that what is happening is not a partisan dispute about who wins specific cases, but a genuine institutional threat that transcends the political divides within the court. The specific trigger for this wave of judicial pushback was the tariff ruling. The Supreme Court struck down Trump's sweeping EPA-based global tariffs, finding that he had exceeded his statutory authority and that the constitutional power to levy import duties belongs to Congress. That ruling was a massive policy defeat for the administration, and Trump's response, which we have covered extensively, was extraordinary in its fury and its institutional disrespect. He called the court completely inept and embarrassing. He called individual justices fools. He called them lapdogs. He said the justices who ruled against him were a disgrace to the nation. He claimed without any evidence that they had been influenced by foreign interests. He said he was ashamed of justices he himself had appointed, and he publicly characterized the ruling as driven by disloyalty rather than by law. That pattern of response, calling justices fools and lapdogs and disgraceful and disloyal and foreign influence, is what produced the unprecedented judicial pushback that we are covering today. Courts respond when the attacks cross from political disagreement into something that scholars and the justices themselves have identified as genuinely dangerous. The historical context for this confrontation is important to understand. American constitutional history has several notable episodes of tension between presidents and the Supreme Court. Franklin Roosevelt's famous court-packing threat in the 1930s, when he proposed adding justices to overcome a court that was striking down his New Deal programs, produced its own kind of institutional confrontation. Nixon's resistance to handing over the White House tapes in the 1970s, which the court ultimately forced through a unanimous decision, tested the boundary between presidential privilege and judicial authority. But in both of those historic confrontations, the presidency and the court were fighting over legal and constitutional principles through the formal mechanisms of the legal system: cases, orders, opinions. What is happening now is different. The president is attacking the court not through legal process, but through social media, public speeches, and media appearances, calling justices fools, lapdogs, and foreign influence, questioning their motives and their loyalty in terms that are personal and contemptuous rather than legally substantive. That is the specific novelty of the current confrontation. And the response from the justices, speaking out through speeches and interviews rather than through opinions, reflects the reality that when an attack comes through informal public channels rather than through legal process, the institutional response also needs to engage those informal channels. Roberts and Gorsuch and Jackson are doing something new because the president is doing something new. And the precedent that gets established by how this confrontation resolves will shape the court-presidency relationship in ways that will outlast both of them. The response from the president to the judicial pushback has been telling. After Roberts' speech, after Gorsuch's interview, after Jackson's public statements, Trump did not moderate his attacks on the court. He escalated them. He continued to call justices who ruled against him on tariffs a disgrace. He continued to characterize the ruling as driven by foreign interests. He said he was ashamed of the justices he had appointed who joined the majority, and he continued to frame the judicial pushback against his attacks as self-evidence of bias, as if justices defending judicial independence from presidential attack is itself a form of political opposition rather than the exercise of their constitutional function. That response, escalation rather than moderation in the face of genuine institutional pushback, fits the pattern of behavior we have documented throughout Trump's relationship with the judiciary. Courts find him in contempt multiple times. He attacks the judge louder. The Supreme Court strikes down his tariffs. He calls the justices fools and lapdogs. The Chief Justice says the attacks are dangerous and have to stop. He continues attacking. At each step, the institutional response is to assert limits and principles. At each step, the response from the president is to push harder rather than to acknowledge those limits. And the question hanging over all of it is what happens when pushing harder eventually runs into institutional consequences that cannot be ignored or absorbed. The public positioning of justices, speaking out in speeches and interviews rather than limiting themselves to their opinions, represents a significant institutional development. Supreme Court justices have traditionally been among the most publicly reticent figures in American civic life. They write opinions. They occasionally give speeches at judicial conferences or law schools, but they very rarely give interviews on political topics. They very rarely use public platforms to address specific political actors or specific patterns of presidential behavior. The fact that we now have multiple justices speaking publicly through speeches and interviews about the threat that presidential attacks represent is itself a significant institutional development. It suggests that the traditional posture of silent institutional dignity, writing opinions and letting them speak for themselves, has been judged insufficient as a response to the specific and sustained pattern of attacks that the president has mounted. The justices who are speaking out have concluded that staying silent while the president publicly calls them fools and lapdogs and foreign influence would itself be damaging to the court's institutional standing. Because silence in the face of those attacks might be read as acceptance, and so they are speaking. Carefully in Roberts' case through the frame of principles rather than specific political actors. More directly in Gorsuch's case, stating clearly that loyalty runs to the Constitution, not the appointing president. Most directly in Jackson's case, naming intimidation as the apparent purpose. All three approaches are extraordinary by historical standards, and all three reflect a judicial institution that has concluded that the attacks have crossed a line that requires a public institutional response. The specific context of what Roberts said about the word dangerous deserves particular attention. Roberts has been the Chief Justice since 2005. He has presided over the court through enormously contentious periods. He has navigated the court's institutional standing through decisions that generated intense political controversy from both left and right. He knows what he is doing when he chooses to speak publicly about threats to the judiciary. And when he uses the word dangerous, when he says that personally directed hostility directed at named judges and justices is dangerous, he is acknowledging a specific and documented reality. The reality that personal attacks on judges by public figures with large followings generate threats against those judges. Documented, specific threats that require security responses. That change the daily lives of the people being attacked, that have in some cases resulted in actual violence or attempted violence. The federal judiciary's own threat tracking data shows that threats against judges increase significantly when high-profile public figures attack them by name and question their integrity and motives. Roberts knows that data. He has access to the security reports. And when he says the attacks are dangerous, he is not speaking metaphorically. He is speaking about actual physical danger to actual human beings who serve the judiciary. The attacks also have consequences for the court's institutional standing that go beyond the physical safety of individual justices. When a president publicly frames rulings he disagrees with as acts of disloyalty, he is implicitly arguing that the court's decisions should be evaluated not by their legal reasoning, but by their political consequences. He is suggesting that justices who rule against his interests are betraying some obligation they owe to him personally. That framing, if accepted by the public, would fundamentally change the relationship between the court and the other branches of government. The court's authority, the ability to issue rulings that the other branches respect and comply with, does not rest on physical force. It rests on institutional legitimacy, on the shared understanding that when the court speaks on questions of constitutional and statutory law, its word is final and binding regardless of how powerful the parties on the losing side of the ruling are. When a president publicly calls justices who rule against him fools and lapdogs and disloyal and foreign influence, and then continues to use the powers of his office in ways that the court has found unlawful, he is attacking the foundation of that institutional legitimacy. He is saying implicitly that the court's rulings are not the final word, but merely one input in a political calculation that he retains the authority to reject or ignore. Roberts and Gorsuch and Jackson are pushing back against exactly that implication. They are asserting in their own voices that the court's authority is real and its independence is genuine. The attacks on it are dangerous, not just to the individual justices being attacked, but to the constitutional order that the court represents. The response from the legal community to the justices speaking out has been significant. Law professors, former judges, and constitutional scholars have largely praised the justices for defending the institution. Many have noted that the traditional silence of the court in the face of political attacks may no longer be sufficient in an era where attacks are personal, sustained, and directed at the legitimacy of the institution itself. Some have argued that the court needs to do more, that speeches and interviews are not enough, that the court must find ways to communicate more directly with the public about its role and its importance. Others have expressed concern that the justices speaking out may politicize the court further, that public statements about political attacks may be read as political positioning rather than institutional defense. These debates reflect the difficulty of the position the court finds itself in. Silence is read as acceptance. Speaking out is read as political engagement. There is no course of action that is free of risk. The specific language that the justices have used is worth examining closely. Roberts spoke of principles rather than specific actors. He framed his remarks as general observations about the need to protect judicial independence. But everyone who heard his speech understood who he was talking about and what he was responding to. Gorsuch was more direct. When asked about the president's suggestion that justices owe loyalty to the person who appointed them, he rejected that suggestion explicitly and unambiguously. "It is really just that simple," he said. The simplicity of his response was itself a powerful statement. There is no complexity here. There is no ambiguity. Judicial loyalty runs to the Constitution and the laws, not to any president. Jackson was the most direct about the nature of the threat. She characterized the attacks as seemingly intended to intimidate the judiciary. That is a specific allegation about purpose and intent. It goes beyond saying the attacks are wrong. It says they are designed to achieve a specific unconstitutional effect, the intimidation of judges. The significance of this confrontation extends beyond the immediate conflict between the president and the court. It raises fundamental questions about the future of the constitutional order. The system of checks and balances that the founders created depends on each branch of government respecting the authority of the others. The court depends on the executive to enforce its rulings. The executive depends on the court to provide constitutional legitimacy for its actions. When those relationships break down, when the executive attacks the legitimacy of the court and the court feels compelled to respond publicly, the system is under strain. The question is whether that strain will produce a new equilibrium or a breakdown. What happens when the president attacks the court pushes back, and the president escalates? How far can this cycle go before something gives? The human dimension of this story should not be forgotten. The people the president is attacking by name, calling them fools and lapdogs and disloyal and influenced by foreign interests, are real human beings who face real consequences from those attacks. Federal judges and justices are already among the most systematically threatened public officials in the country. The federal judiciary tracks threats against judges, and the numbers are alarming. Threats have increased dramatically over the past decade as political rhetoric has become more heated and as social media has made it easier to direct large audiences against specific individuals. When the President of the United States calls named justices fools and says he is ashamed of them and questions their loyalty and their integrity on a platform with tens of millions of followers, some percentage of those followers will conclude that aggressive action against those justices is justified or even righteous. That is the specific mechanism by which Roberts' word dangerous applies. Not metaphorically, literally. Named attacks by high-profile public figures generate documented threats against the named individuals. The judges and justices who are being attacked live with the security consequences of those threats every day. That human reality, the actual physical risk created by the pattern of attack that Roberts identified as dangerous, is the most urgent reason why the justices speaking out matters and why the escalation of those attacks matters. It is not just about constitutional principles and institutional standing. It is about the safety of real people doing an important and difficult public service. The future of the relationship between the presidency and the judiciary depends on how this confrontation resolves. If the court's public pushback succeeds in moderating the attacks, the confrontation will have established a new boundary, a line that presidential attacks cannot cross without provoking an institutional response. If the attacks continue or escalate despite the pushback, the confrontation will have established the opposite boundary, that the court's institutional defenses are insufficient to protect it from sustained presidential attack. The role of Congress in this dynamic is important to consider. Congress has constitutional authority over the federal judiciary. It controls the court's budget. It has the power to change the court's jurisdiction. It could, in theory, act to protect judicial independence through legislation. But Congress has shown little appetite for confronting the president on this issue. Republican members have largely remained silent about the attacks on the court. Democratic members have criticized the attacks but lack the power to do anything about them. The political incentives for Congress to act are weak, even as the institutional need for action grows stronger. That gap between institutional need and political willingness is itself part of the problem. The court cannot defend itself alone. It needs the support of the other branches and of the public. If that support is not forthcoming, the court's institutional standing will continue to erode. The public's response to this confrontation will also shape its outcome. The court's authority depends ultimately on public acceptance of its rulings. If the public comes to see the court as a political institution rather than a legal one, its ability to function as a check on the other branches will be diminished. The president's attacks on the court are designed to produce exactly that outcome, to make the court seem political, partisan, and untrustworthy. The justices speaking out are trying to counter that narrative, to assert that the court is independent, principled, and worthy of public trust. Whether the public accepts that assertion or the president's narrative will determine the court's institutional standing for the foreseeable future. The confrontation between Trump and the Supreme Court is ultimately a test of whether the American constitutional order is going to hold. The court is one of the three co-equal branches of government. Its authority rests on institutional legitimacy, on the shared understanding that when the court speaks on questions of constitutional and statutory law, its word is final and binding regardless of how powerful the parties on the losing side of the ruling are. When a president publicly calls justices who rule against him fools and lapdogs and disloyal and foreign influence, and then continues to use the powers of his office in ways that the court has found unlawful, he is attacking the foundation of that institutional legitimacy. He is saying implicitly that the court's rulings are not the final word, but merely one input in a political calculation that he retains the authority to reject or ignore. Roberts and Gorsuch and Jackson are pushing back against exactly that implication. They are asserting in their own voices that the court's authority is real and its independence is genuine. The attacks on it are dangerous, not just to the individual justices being attacked, but to the constitutional order that the court represents. Whether that assertion holds, whether the institutional legitimacy of the court survives this confrontation intact, depends on factors beyond any individual speech or interview. It depends on whether Congress acts to protect judicial independence. It depends on whether the political community responds to the attacks with condemnation rather than encouragement. And it depends ultimately on whether the American public continues to recognize the court as a legitimate institution whose rulings deserve compliance. We are watching that test in real time, and the outcome is genuinely uncertain. The presidential attacks on the judiciary are not just about the specific rulings the president disagrees with. They are about something more fundamental. The question of whether the president accepts the legitimacy of judicial review, the principle that courts can strike down actions of the executive branch when those actions exceed constitutional or statutory authority. The president's attacks on the court suggest that he does not accept that principle. They suggest that he believes his own interpretation of the law should be binding even when courts disagree. That is a position that is fundamentally at odds with the American constitutional tradition. The court's pushback is a defense of that tradition, an assertion that the president is not the final arbiter of constitutional meaning, that the court has an independent role to play in interpreting the law, and that presidential attacks on the court will not deter the justices from performing that role. The coming months will reveal whether the court's pushback changes the dynamics of the confrontation. The president may escalate his attacks. He may continue to call justices fools and lapdogs. He may seek other ways to pressure the court. The court may respond with further public statements. It may find other ways to assert its independence. The cycle could continue indefinitely, or the confrontation could reach a breaking point where something fundamental changes. The president could go too far and provoke a response from the other branches. The court could issue a ruling that directly challenges presidential authority in a way that forces a confrontation. The political environment could shift in ways that change the incentives for all parties. The outcome is genuinely uncertain. What is certain is that the confrontation matters. It matters for the court. It matters for the presidency. It matters for the constitutional order. And it matters for the future of American democracy. The decision by the justices to speak out publicly was not made lightly. They understand the risks of engaging in public controversy. They understand that their statements will be analyzed, debated, and used by both sides in political arguments. They made the calculation that the risks of speaking out were less than the risks of staying silent. That calculation tells you something important about how serious they believe the threat to be. They have concluded that the traditional posture of the court, silent institutional dignity, is no longer adequate to protect the institution from the specific and sustained pattern of attacks they are facing. That conclusion is itself a significant statement about the state of the relationship between the presidency and the judiciary. It tells you that the norms that have governed that relationship for generations are under strain, and that the strain may be approaching a breaking point. We will continue to watch and report on this story as it develops.